Hi everyone, this is Justinian Lane of Justinian Associates, and today I have with me
Dustin Fox with Justinian Associates.
Hi, Erik Walker, also with Justinian and Associates.
and we're going to talk a little bit today about South by Southwest, which is coming up. There's obviously a big festival with a lot of alcohol consumption, which is great for the economy, but there's of course a lot of issues that come along with alcohol consumption. So we're going to talk today about what happens if you drive drunk, and if you have to take a breath test to be proven drunk, or if there's other ways they can prove that you were intoxicated. And then also, if you're hit by a drunk driver, what kinds of options you have on who you can sue. We'll start there because we do that a lot. We don't like people who drive drunk, and we will sue drunk drivers. It's important to us to make sure that people are responsible behind the wheel. And one of the first things that we do if one of our clients is hit by a person who is intoxicated, is we see if the bar or establishment that served the alcohol could be held responsible. And that's an area of law that is called dram shop. And it goes back to an old English measurement of alcohol called a dram. That's where the dram comes from. And we'll let Erik talk a little bit about what the dram shop laws are in Texas.
Essentially, if a proprietor who sells alcohol, or frankly, a homeowner who provides alcohol to people in their home, provide alcohol knowing that a person is drunk, or in a situation where they should have known that the person is intoxicated, and they know the person is going to drive a vehicle or potentially could drive a vehicle, they can be liable for damages for any accident that individual causes. Essentially, in a Dram Shop Act case, the plaintiff would sue the proprietor of the bar, the owner of the bar. The owner of the bar would probably then countersue the drunk driver if you had not already sued, the plaintiff had not already sued the drunk driver. And the jury would apportion liability between the bar and the drunk driver. Each would be responsible for their respective percentage of responsibility. So for instance, if the jury found that the individual was injured to the extent that they are entitled to $30,000 in damages, and they found that the bar was 67% responsible and the drunk driver was 33% responsible, then the bar would be liable for $20,000 in damages and the drunk driver for $10,000.
Perfect. Yeah. The way you have to prove that the bar, the establishment was responsible, one of the important things to look for was the person visibly intoxicated? Did they have did the bar have a way of knowing that the person was too intoxicated to safely serve? I know Dustin is working on a couple of those kinds of cases. And can you talk a little bit about the kinds of investigation and things that we do to see how we can do that?
Yeah, so as soon as we get that type of client, we send a spoliation letter, so we try to see if there's video of them around the area to see if they were visibly intoxicated.
What does spoliation mean, by the way?
Yeah, so you send a letter, and that means that they'll just basically not destroy the evidence. So if they destroy evidence or they get rid of the video, there's a presumption in the court that, hey, why did you destroy this evidence? And the jury's allowed to hear this. But yeah, so we'll see if they're visibly intoxicated, stumbling around possibly. Maybe we can do some depositions and witnesses, get the witness statements to see, hey, were they slurring their words, stuff like that, to see how intoxicated they actually were.
Right, and we'll use an investigator to see who was working that night, if the bartenders or patrons, if we can track any of those down and talk to them and what their recollections are. Really, in cases like this, time is absolutely the essence. If you were hit by a drunk driver, or a loved one was, and you think there's a possibility that an establishment was involved, you should hire an attorney quickly so they can look to see if security camera footage exists. Most establishments don't keep the footage for very long if there was no reason to. So, maybe it's 3 days, 5 days, 7 days before they just tape over it. So the quicker the better, and we'll try to get that video footage and see what's there. Another really important thing to look for is there's a provision in the law, they call it the Safe Harbor Act, or the Safe Harbor provision of the dram shop laws. Basically says that if every employee is specially trained by the Texas Alcoholic Beverage Commission and follows certain procedures, then the bar basically gets out of jail free. I'm not going to say it's easy to pierce that safe harbor, but it's not very difficult. There's even if the training was performed, there's usually many instances and ways to get around that, and that's one of the advantages of hiring a law firm that routinely sues bars and establishments. Now, Erik also mentioned there's the proprietorships, the dram shop, the bars. He also mentioned like if you're at somebody's house, and those would be called social hosts. What are the obligations there, Erik, for serving your friends or family?
Well, I think it's this negligent standard once again. You have a duty when you're the one providing alcohol to individuals not to create a situation where somebody becomes a danger to others. I'm not that familiar with the laws on that because it's rarer that we would actually go after that kind of individual. Typically, we sue bars or restaurants or business establishments that provide alcohol, but there is some liability for anyone really who creates a dangerous situation by serving people who are obviously intoxicated.
And additionally, there's criminal penalties if you're serving underage people at your house. So I know a lot of people have a cool mom or a cool dad who think it's okay to let your underage people come over and drink. If, God forbid, they cause an accident, there could be some criminal liability for the adults that knowingly served alcohol to the minors. So those are the kinds of things we look for is where was all the drinking done? Was it at multiple bars? We can look and get bank statements and credit card statements to see where were they drinking, where were they going, and start piecing timelines together. And then it's important for us to try to figure that out. If the drunk driver had taken a breathalyzer or a blood test, then we have a really good idea. Hey, look, they were at 0.10 or whatever, and we can kind of piece together. They started drinking at this time and they stopped at that time. So we'll do those kinds of investigations to see who we can sue. Right now, unfortunately, there's a bill pending in the Texas legislature that will make it much more difficult to sue bars. Bars have a pretty good lobby in this state, and they want the safe harbor provision to get extended even further, such that you basically can't sue bars. Every year, there's always some industry that says, "Hey, we want protection from lawsuits," and sometimes they get it, and sometimes they don't. South by Southwest is going to have a lot of good activities in downtown. There's going to be a lot of alcohol consumption in private events. So that would be another thing that we'd look for is was a big company hosting this event and they had an open bar and they were letting people get visibly intoxicated. Another issue that we can look for is it usually comes up in the social environment, like at a house. If you know that somebody is drunk, are you allowed to just let them take your car, Dustin? Is that something we're allowed to do?
No, absolutely not. I would highly recommend you do not let someone that you know is visibly or you just know is intoxicated to drive your car. You can be also held responsible for that. Negligent entrustment, I believe, is that correct? Yes. Yeah,
it'd be negligent entrustment of a motor vehicle. Is if you know this person is intoxicated and you give them the keys anyway. We really want to discourage drunk driving, especially during the event that's coming up. And one of the things that you can do to not necessarily have to drive drunk. I mean, if you want to go to South by and get sloshed, go right ahead. I mean, that's what these festivals are for, right? Mm-hmm. But you can either use a cab or you can use rideshare apps. Here in Austin, we no longer have Uber or Lyft, and actually I had to use the alternative that we have now is called Fare, F-A-R-E. You might remember last week I talked about how excited I was to possibly get picked for a jury.
Did that happen?
It did not happen, but I'm not totally let down because nobody got picked. We all reported for jury duty, and we waited outside, and the bailiff came out and announced to everybody that all of the cases that had been set that day had been resolved, and all we had to do is sign our piece of paper to show that we met our civic duty, and then we had an option. Our first day of jury service, we would go get $6, and we either fill out the address where we want our check sent, or they have charities that you can donate your $6 to. So I chose to donate my $6 to the Texas Crime Victims Compensation Fund. On that subject, with jury duty and things like that, Erik, you spend a lot of time in court. How common is it that cases get dismissed before trial?
The vast majority of cases either get dismissed by the court or settle. Really very few cases, and by very few I mean a tiny percentage of cases actually go to trial. The key is whether or not the plaintiff's lawyer, the lawyer representing the victim, the one suing the wrongdoer, is willing to go to trial, because that dictates how much the settlement is for. I think we talked last week about how a lot of, frankly, most of the advertising lawyers, the ones who beat their chests in advertisements in this community, are lawyers known for not going to court. They instead have mass number of clients, almost an assembly line of clients, and they make their money in volume, not in getting high settlements for individual clients. Our firm and some others are firms that will go to court, and we will take a case all the way through trial, and consequently, if we settle on the courthouse steps, the defendant's going to know we're settling because they decided they didn't want to go to trial, not because they knew we weren't willing to go to trial, and that's a big difference.
And that happens with some frequency, that especially like a product liability, or you're suing a big corporation where there's things that they would like to keep secret, that once you go to trial and evidence is introduced into court, it becomes public record, and anybody can do whatever they want with it. It can be published by the news. So if there's dirty laundry that some company doesn't want aired, they really, really want to stay out of court, because once it's introduced, it's there forever. So we don't see confidential settlement things like that as often in our dram shop or drunk driving type of cases, because there's not dirty secrets that the companies are trying to keep. Maybe some bars, they've gotten sued over and over again and they don't want their records to come out, but for the most part, that's not the same kind of an issue.
Let me add something on the alcohol cases. First of all, one of the things about suing homeowners that everyone should bear in mind is that homeowners insurance comes into play, and often the policy limits, the amount of money that the insurance company is obligated to pay under a homeowner's policy, is much higher than the amount a car insurance policy would involve. And so one of the reasons we might target in a trial or in a case, a lawsuit, a homeowner, is to try to secure for our client the limits, or as much as we can of the limits of the homeowner's policy. And I know there's some people watching this who are saying, well, gosh, why are you suing everybody? You sue bars and you sue homeowners. And well, look, if somebody's a victim of drunk driving, they're the ones who've been harmed. They're the ones who deserve compensation. And people who contributed to that by knowingly serving somebody who was visibly intoxicated and a danger to others ought to pay that individual. The victim shouldn't be left not made whole because someone has an aversion to suing people. If somebody is responsible for creating a dangerous condition, and that dangerous condition causes somebody injury, the person creating the condition is liable to the injured party.
One of the big misconceptions too is that we're suing the individual to ruin their lives. There's always insurance, but we don't get to talk about that in court, do we?
No, insurance doesn't come up in court because the law views that as prejudicial bias, that juries would be more likely to award damages if they know that a faceless insurance company is paying as opposed to the individual actually being sued. But in the end, most of the time, the amounts in judgments and in settlements are monies paid for by insurance companies.
It's incredibly rare that we would take a case where there isn't insurance company involved, because in a drunk driving case, the damages could be hundreds of thousands of dollars, and the average citizen doesn't have that kind of money. Typically, if you have money, you have insurance, especially since you have to have insurance to drive. So that's what's the importance of insurance is. If a case is going to trial, 999 times out of 1,000, there's an insurance company or some other company that's paying. It's not the individual. And I want to touch on a point that Erik made about making the victim whole, that they shouldn't have to pay. I have a lot of conservative friends that are kind of biased against lawyers and lawsuits in general. But one of the things that they understand and resonates with them is, if an individual goes out and they're minding their own business and a drunk driver hits them and they're paralyzed and they need medical care for life, we end up paying for that through Medicare or Medicaid or other government disability programs. So they always say there's no such thing as a free lunch. That's true. The costs of medical care get passed to whoever can pay it. And if it's a catastrophic injury, oftentimes that's taxpayers through Social Security disability. It's not terribly uncommon for a lifetime of medical care to run into the millions of dollars. I saw one case where it was an individual in their 20s that was rendered brain damaged and was going to need 24-hour care for the next roughly 50 years, and it was about $20 million in costs. Taxpayers have to pay for a lot of that. And that's fine. We live in a society where we're not going to just throw people out into the streets. But part of, I think, everyone's obligation is to do what you can to not have to put those bills onto taxpayers. And that sometimes means filing a lawsuit, even if you're not the kind of person who sues. It's just saying that you're the kind of person that will take money from taxpayers to protect a guilty party. It just doesn't make much sense to do that, especially if, I like bars, I go to bars, I like to drink. if one of them does something that breaks the law, I'll hold them accountable. Surely you would agree that if they're underpouring purposely, that they should be held accountable. You should get a refund. If they're overpouring and getting people drunk, they should be held liable for those consequences. So that's what we look for is what was the wrongdoing act. It's important to engage somebody early on who will have the resources to look to see where a person was drinking, and that could be very difficult during a festival like South by Southwest. There's going to be people just going all over. I'm sure there'll be some cash bars, some open bars. We really want to encourage everybody who's going to go down there to have a good time and be safe. My experience with that Fare app was good. I had no problems. My driver was courteous and polite, got me where I wanted to go, took a good route. It was very easy. I signed up for the app literally on the courthouse steps. I had someone drop me off. I thought I was going to be there all day. It took me a minute to sign up for it. So if you're coming into town, be aware there is no Uber, there is no Lyft, there is Fare, F-A-R-E. It's a good app. It works just fine, and I'm sure that it's going to be just saturated all through South by Southwest. Cars will be hovered all over the place. And plus, there's plenty of public transit options too. So the big thing for you to not do is to drive drunk, because there's another thing that comes into play called punitive damages. Can you talk a bit about punitive damages, Erik, and why they're available in drunk driving cases?
Yes, in situations where a person's misconduct is not just negligent, meaning it's not just conduct that deviates from what a reasonable person would do, but it's outrageous conduct. We call it gross negligence or malicious conduct. A total disregard for the rights of others. There are damages available called punitive damages. Essentially, there are two kinds of damages in a lawsuit: compensatory damages or actual damages, and punitive damages. Compensatory damages or actual damages are the ones designed to make the person whole, to give them compensation for all of their medical expenses, lost wages, pain and suffering, mental anguish. But in addition to damages to try to make the person whole again, we have punitive damages. They are designed purely to punish the wrongdoer and to deter future wrongdoing from that person or company and others similarly situated. So punitive damages are designed to punish the bar that overserved somebody knowing that the person was drunk and an extremely drunk person and was a danger to others, and also to deter other bars in the future from serving people who are so obviously drunk that they are an imminent danger to other people. Or in a situation where you're actually found to have been guilty of drunk driving, you could be assessed punitive damages because just the act of drunk driving is deemed to be gross negligence or malicious conduct. And punitive damages can be awarded against you if you're drunk driving. That's another reason it's important to avoid driving drunk. But it also indicates that if you are the victim of drunk driving, you could be entitled both to damages for your injuries and punitive damages to punish the person who caused your injuries.
And an interesting thing about punitive damages is we talked a few moments ago about insurance companies. You cannot insure against punitive damages. And that's because we want to make sure that the person being punished is the one that actually feels the pain. There's the old, stories about princes back in the day having whipping boys to take their punishments for them. We don't let that happen with punitive damages. So in a situation, if you have a fair amount of assets, like I have a decent amount of assets, but I also have a very large insurance policy. So if I cause an accident, there's 7 figures available to compensate somebody. But if I go out and I drive drunk, well, that's not going to pay for the punitive damages. So a law firm would have every incentive to take me to trial and get whatever they can get from the jury and try to get punitive damages. And in that case, the insurance company would pay for the compensatory, what Erik was talking about, the damages designed to make the victim whole, but it would not cover the punitive damages. And punitive damages can be a multiple of whatever the compensatory damages are. And I know in the product liability cases that we come up with a lot, punitive damages come into play. And can you talk a little about the limits on the ratio, the multiplier, how that works with punitive damages?
My recollection is that punitive damages are limited to $250,000 or twice, compensatory damages, whichever is greater.
Right, and that's in Texas. And
that's in the state of Texas.
And federal constitutionally?
Well, different. It's going to be state by state, the restrictions on punitive damages. although there are United States Supreme Court decisions indicating that no state can allow an excessive amount of punitive damages. It's very, very ambiguous what constitutes an excessive rate of punitive damages. In one appeal called the State Farm case, it's often just referred to as State Farm, the court found a 10-to-1 ratio to be the outer limits of what would be acceptable, 10 times compensatory damages for punitive damages. In other cases, courts have found that much smaller ratios are the limit. In some courts have found that a 2-to-1 is the limit, or 3-to-1. It's ambiguous, but understand that punitive damages are not a windfall that will make somebody, richer than anyone in the world. We don't allow that anymore. There are limits placed upon them.
And even after punitive damages are awarded, the judge has discretion, right, to lower that amount?
Yeah, judges can lower any damages. If a judge deems a jury's award to be excessive, either on compensatory damages or on punitive damages, the judge can issue what's called a remittiture, which is a reduction in the damages that have been awarded by the jury.
Right, and punitive damages, they're very rare. They don't get to you don't even get to ask for them unless, as Erik mentioned, gross negligence, the kind of conduct, very reckless disregard. You know that the chances are very high that what you're doing is going to harm someone. That said, they're a very effective way of punishing, especially corporate defendants, that the only way you can really get to them is hitting them in the pocketbook. So if you can get whatever that multiple is, 2 or 3 or 4 times the verdict, then that would be a very good thing to help tell them that that sort of thing is not acceptable in the community. As an interesting aside, I'm such a fan of punitive damages that when I was in law school, I had 2 vehicles. Well, I had one and then I had another. My first custom license plate was punitive, and then the other was damages. So I was kind of a fan of that. We don't get them very often, but they're one of the most effective tools that we do have. And courts in Texas especially, because they're pretty conservative, they go out of their way to take punitive damage awards away from the person that they're awarded to. As far as I know, there hasn't been any big cases where punitive damages were taken away in a drunk driving case, and I would speculate that as conservative as the Supreme Court here is in Texas, they're not going to have a lot of sympathy for a drunk driver. So again, there's so many things you can do to avoid getting that. And the last thing to talk about is, we all know, you take a breathalyzer, different states have different limits. It's 0.08 here in Texas. But even if you don't have a breath test, there are other ways that you can be proven to be intoxicated. Isn't that right?
Oh, yes. In fact, often a police officer will do what's called a field sobriety test first, in which we've all seen this in movies. Some of you may have been subjected to this, where you have to touch your nose with both hands, with your eyes closed, where you have to say the alphabet, sometimes backwards, or you have to count backwards, walk a straight line, the test with a light in front of your eyes to see if your eyes deviate in some way from following the trail of the light. And the field sobriety test can be used to establish intoxication independent of a breathalyzer. In fact, many people turn down the breathalyzer because it's well known that just a few drinks can put you over the legal limit of 0.08, which is a presumptive establishment of drunk driving. And if you do turn down the breathalyzer, you can still be held liable for drunk driving. You can still be criminally liable for failing the field sobriety test or otherwise indicating your intoxication by your conduct on the road.
And if you are found guilty in a criminal proceeding for driving while intoxicated and we're suing you, we get to use the stuff from the criminal court to come in, and that's going to be very bad for you. So I implore all of you, come to South by Southwest and have a good time. Go have some drinks, enjoy yourself, see all the fun things in Austin, but do not get behind the wheel. Use the Fare app. I think there's still taxis. You could probably find one. I'm sure Google can get you a taxi. Every hotel is going to have shuttles. Be responsible. Don't go out and put your life at risk and other lives at risk. And as crass as it sounds, don't put your assets at risk either, because you don't want to lose all your money, even if you don't really hurt somebody. There's no good that can come of getting behind the wheel when you're intoxicated. So please don't do it. You might have seen on TV, we have sponsored public service announcements. We're on every month on the networks, showing usually Dustin talking about the dangers of drunk driving. It's something that we paid money to do, to sponsor, because we feel very passionately about it. We don't want people to do it. So that's the message for the day. If you're going to drink, have fun, but don't get behind the wheel. That's all I've got for today. I'm Justinian with Justinian Associates.
Dustin with Justinian Associates.
And Erik.
Thanks, and have a good South by Southwest.